Your right to counsel is provided by both the U.S. and Texas Constitutions. While in general it's a good idea to take a lawyer with you when facing confinement, some defendants choose to represent themselves. This is referred to in Latin as a pro se defendant. In this screencast, we'll discuss how a defendant waives their right to counsel in order that they may represent themselves pro se. In order to allow a case to progress more quickly, the 10 days an indigent or non-indigent defendant has to prepare for trial after getting a lawyer may be waived, in writing or on the record in open court. In addition to waiving the 10-day minimum, a defendant may then waive their right to have an attorney. A defendant may voluntarily and intelligently waive the right to counsel in writing. The judge must confirm that you are making a decision without outside pressure and you understand you know what you're doing. The system is very cautious on behalf of criminal defendants who are without a lawyer. Between the time a defendant is booked into jail and the time a defendant is appointed or retains a lawyer, there's going to be a time gap. The Code of Criminal Procedure first imposes restrictions on the prosecutor during this time. During this time, the prosecutor may not ask for or obtain a waiver of the right to counsel while the defendant is not represented, or communicate with the defendant who has requested appointed counsel unless the judge has already denied the request for counsel and the defendant has been given reasonable opportunity to retain private counsel, or the defendant has already waived the opportunity to retain private counsel. Next, there are also restrictions on the judge. These apply in any confinement case, in other words, a case which is a B misdemeanor or up. The judge may not direct or encourage the defendant to communicate with the prosecutor unless the judge advises the defendant of the right to counsel and procedure for requesting counsel, and the defendant has been given a reasonable opportunity to request counsel, or the request for appointed counsel has been denied and the defendant has been given reasonable opportunity to retain private counsel, or finally, the defendant has waived the opportunity to retain private counsel. So, the CCP is designed to make sure the defendant experiences no outside pressure to waive his or her right to counsel. If in the end the defendant still wants to waive his or her right to counsel, they may do so voluntarily and intelligently. As a final safeguard, the judge shall advise the defendant of the nature of the charges against him and the dangers and disadvantages of self-representation. Again, this applies to B misdemeanors and up. If the defendant still wants to waive his or her right to an attorney and the court determines the waiver is voluntary and intelligent, the judge shall provide the defendant a written statement to be included in the record. A defendant's decision to represent themselves, which is more than likely a bad idea, is not irreversible though. A defendant may withdraw their waiver of counsel at any time, but they are not entitled to repeat any proceeding held when their waiver was in effect. So, a defendant may decide in the middle of trial things aren't going so well and ask the judge to have appointed counsel. Once counsel is appointed, however, the trial will pick up right where it left off. There are takebacks, but no do-overs. If a waiver of the right to counsel is withdrawn, the court may allow the newly appointed counsel 10 days to prepare. These are very strict guidelines to protect the right to counsel. The restrictions are less, though, if the indigent defendant is released from custody prior to the appointment of counsel. In other words, they make bond. In this case, the appointment of counsel is not required until a defendant's first court appearance, or when adversarial judicial proceedings are initiated, whichever comes first. This would seem to be an unlikely situation, however, since a defendant who can't afford to hire an attorney probably can't afford to pay his or her bail either. Finally, a judge may appoint new counsel for an indigent defendant if the defendant is charged with a new or additional crime, or for good cause stated on the record. An example of this is when a DWI defendant is later charged with a very serious offense, such as a murder. A DWI attorney may or may not be experienced enough to try a murder case, or, in the case for good cause, an indigent defendant may request to fire his or her court-appointed attorney. If the judge believes there's good cause, he or she may grant this request and appoint the defendant a new attorney.